नमस्कार दोस्तों, और जैसा कि काफी दिनों से हमारे कुछ सेशंस हम हिंदी में ले रहे हैं, एडवोकेसी स्किल्स के ऊपर तो कई बार टॉपिक हुआ, बट ज्यादातर इंग्लिश में रहे। तो हमने जो पहले भी एक सेशन दे चुके हैं, सीनियर एडवोकेट रतन के सिंह, who is a brand name in the field of arbitration, especially the construction law. तो एडवोकेसी स्किल्स की जब बात हुई तो एक ये भी सवाल उठता रहा बार बार, जो लोगों के जहन में आता है कि जो एडवोकेसी स्किल्स हैं, क्या ये एक आर्बिट्रेशन एक्ट के लिए अलग है? अलग है तो किस तरीके से अलग है, और इन स्किल्स को कैसे एनहांस किया जा सकता है? क्योंकि एक बेसिक जो बार बार सबके जहन में बात आती है कि भाई जो ये नॉलेज तो हो गई, पर उसे प्रेजेंट कैसे करना है, क्रॉस एग्जामिन कैसे करना है, बुक्स एंड जजमेंट्स को कैसे पढ़ना है, ये सवाल उठते रहे हैं और इनके उत्तर मिलते रहे हैं। पर तब भी यंग लॉयर्स और लॉयर्स बार बार कहते हैं कि जितना समझ लिया जाए, जिन लोगों ने अपनी एक जिंदगी में छवि बनाई हुई है, अगर वो समझा सकें तो सबसे बेहतर है। और संडे का दिन लोगों का जब घूमने का दिन, पर जैसे कहते हैं रतन जी अपने नाम के अनुसार एक अनमोल रतन है नॉलेज शेयरिंग के लिए, इसलिए संडे को वाले दिन लोग जब सारा घूमने फिरने की बजाय नॉलेज समझना चाहें तो वो अपने बात में ही एक इस चीज की पुष्टि होती है कि भाई उनका कितना बड़ा नाम है। ज्यादा समय नहीं लूंगा और मैं अपने, अब तो हम ये भी कह सकते हैं जब वर्चुअल प्लेटफॉर्म पे मिले मित्र रतन के सिंह को बोलेंगे कि भाई ये अपने इनसाइट्स दें और हम इन चीजों को आगे लेते हुए चलें। ओवर टू यू रतन जी।
Thank you, Vikas. I hope I'm audible to all. Okay, great. Vikas ji talked about peculiarities of arbitration advocacy. Is there any peculiarity for arbitration advocacy? That is the topic we need to discuss today. First and foremost is that arbitration is a one-stop shop. Therefore, all the stakeholders should give their 100% in the arbitration. You have no second remedy after award comes. Yes, you can challenge the award on certain grounds, but the threshold for those challenges are so high, you hardly succeed, because the courts, while hearing objections to the awards, are not going into the merits of the awards. So therefore, it's very important that all stakeholders, including lawyers, should give their 100% to the arbitration proceeding. That is very, very important. Now, today, what I have decided is that I'll try to talk about this arbitration advocacy from the standpoint of the arbitrators, which is something very important. Yes, I'm going to cover other areas as well, other aspects as well. And I'd say that there is a very famous saying that you should know the audience, or lawyers must know the audience. Who is your audience in arbitration? Your audience is your arbitrator, the arbitration tribunal. And you must remember, and you should get convinced with one aspect, and that is that arbitrators are human beings. Therefore, you are supposed to deal with the arbitrators in a manner that you are not going on their wrong side. You are not rubbing them on the wrong side. It is not enough to be right in arbitration. It is essential that rightness must be apparent to the arbitration tribunal, who are invested with the authority to determine the dispute. And this is where lies the challenges to the arbitration professionals, the arbitration practices, the arbitration lawyers. And if you ask any arbitrator what he wants from a lawyer, answer, if given fairly, would be that they want simply everything, because their role is to determine the disputes. And your role is to persuade the arbitrator to determine the dispute in the manner you want it to be. And that's why your role in arbitration as an arbitration counsel or party representative is to simplify the arbitrator's job. And therefore, you have to look at the case from the standpoint of the arbitrator. You have to put yourself in the arbitrator's position, defining the issues to be decided and considering what is necessary to prove in order to prove those issues. And therefore, the good lawyers, good advocate, good arbitration practitioner lays the groundwork for a decision or an award from the standpoint of an arbitrator. And everything is done in such a manner that you do hand-holding for the arbitrator. You have to bring the arbitrators out from the thicket of facts, law, allegations, counter allegations, claims. So you have to do hand-holding. Arbitrators should have faith in you, trust in you. That's what it's famously said, that you should never mislead the arbitral tribunal. You have to earn the trust, the faith of the arbitrator. And your role is to not only burden the tribunal with your side of story, your side of case, and then have a hands-off approach. No. You have to not only know your case, that is called KYC. KYC, this expression.
Ratan ji, unmute kar lein. You have to unmute yourself. It's not happening. Yes. Now just check out. I have allowed you.
Yes. Is it okay?
Yeah.
Okay. It seems we lost track of what was happening. I said this. You are not only supposed to burden the tribunal with your case and have hands-off approach. You have to do hand-holding of the tribunal. That is something you must keep in mind. That is why, and that is where advocacy skills comes in. Advocacy skills means what? The Sir Edward Ebert Perry had said that there are 7 limbs of advocacy, and he talked about 7 attributes which any lawyer should possess. Those fundamentals apply to arbitration advocacy as well. What are those 7 virtues or attributes you should possess? 1, honesty. And this applies with full force when it comes to arbitration advocacy. Honesty. courage, industry, wit, judgment, eloquence, fellowship. These are 7 virtues. Now, next thing which you must keep in mind is that arbitration, advocacy, like any other form of advocacy, is an art of persuasion. And therefore, your personal character makes your advocacy credible. It is about stirring the emotions of the hearers, that is the arbitration tribunal. It is about power of proving the truth. Advocacy is essentially also about reasoning logically and understanding human character. This is very important. Sometimes it is said that arbitration, when we talk about arbitration, we essentially talk about commercial arbitration. Now, in commercial arbitration, one would say that arbitrations are essentially about contracts between the parties. Therefore, there is no place for equity, and there is no place for anything equity, I would say. I must tell you, it's not. It is
not just bothering. Somebody has sent that there is voice. The voice is not clear. If the mic could be brought closer.
Okay. Okay. Is it better now?
Gaurav just posted.
Okay.
So you can continue.
Oh, hope it is better now. I would tell you that what you should think about arbitration when you talk about arbitration advocacy. In order to properly appreciate advocacy in arbitration, one needs to appreciate how the practice of arbitration has evolved over time. I was talking about place of equity in arbitration and commercial arbitration. Even if arbitrators, see, I'll tell you, the art of persuasion, when we talk about, it has 2 kinds of effects. One is direct effect, another is indirect effect. Now, this indirect effect, the message which you leave with the arbitrators, your persuasive skills before the arbitration tribunal. Emotional issues. People say emotions have no place in commercial world and commercial arbitration. I don't agree. All these emotions and emotional appeals have its bearing. End of the day, arbitrators are human beings. Now, I'll go into some detail about this as well. But first of all, you need to understand the evolution of arbitration. Earlier, disputes were not as complex as we see today. Now it is increasingly getting more and more complex. And result of this is that not only you have got complex contracts being brought before arbitration tribunals, it is also, there is another shift which we have seen, that is a shift towards written advocacy from oral advocacy. So that is why when it comes to oral, I'm not saying that oral advocacy is completely out of the arbitration ecosystem. No, not at all. In particular in India, oral advocacy carries a lot of meaning. But end of the day, oral advocacy comes in when you are making your oral submissions before the tribunal at the time of final arguments, as we call it in India. There, anything where arbitrators have got confusion about a particular issue or something they have not been able to understand, you simplify, you do all of this. But before they come for hearing, they would have gone through your briefs, or they are supposed to have gone through your briefs. Before that, you are supposed to give them skeleton arguments. Skeleton arguments which is required to be given to the arbitration tribunal, which is very, very important aspect, and one must keep in mind. I'll talk about this in some detail in a while. And again, after your oral submissions, when tribunal goes back to the drawing table and goes back to write the arbitral award, again, what is lying before them is your written advocacy, your submissions, that is the pleadings, your pre-hearing brief, that is the skeleton argument. And post-hearing brief if it is if there is any. So end of the day, this importance needs to be kept in mind of written advocacy. And therefore, one has to learn all the crafts of written advocacy. And therefore, it starts with knowing the case. It starts with having proper knowledge of the language in which arbitration is being conducted, how you express yourself. So all those drafting skills, which is very, very important. Advocacy in arbitration requires adaptability. This is something very, very important. 15 days, 2 weeks ago, I was sitting in an arbitration tribunal where we had claims of approximately 5,000 crores. And I was sitting in the arbitral tribunal as one of the arbitrators. Now, what we found was the tribunal wanted to hear the submissions on certain aspect in a certain manner. But the arguing counsel wanted to argue the way he thought is appropriate. Tribunal will not change you for long, but you must understand you have to satisfy the tribunal. You are not there to satisfy anybody else or your client. You have to persuade the tribunal. For tribunal, certain thing may be important or very important, which may not be that important for you. Tribunal may be wanting to understand a particular thing in a particular manner. Now, it is very important, therefore, that, and as I said, adaptability is the key. Adaptability is the key. Now, second important aspect is that sometimes you have to also understand, keep in mind the composition of the arbitral tribunal. Now, you may have a retired judge as the tribunal member or the chairman or the tribunal member. You may have a lawyer sitting as a tribunal member, and you may have some technical person, such as the engineer or the architect or the quantity surveyor, whoever. You may have industry expert sitting as one of the arbitrators. Therefore, you must know what is the language which is well understood by all the three. Language doesn't mean that English or Hindi. Language means you should talk in such a manner, you should argue in such a manner that the whole tribunal understands you. You should not have, suppose you have two technical members sitting in the tribunal, you should not go into too much of legalese. You should simplify your argument in such a manner that any lay person can understand that. And that is why it is said adaptability. Actually, what happens? The one retired judge sitting as the arbitrator may understand things by giving emphasis on a strict adherence to civil procedure code, which is typically the case in India, though Arbitration and Conciliation Act says that CPC doesn't apply. But most of the retired judges have their training in that particular manner while sitting in court as judges. So they have their own ways to understand things. No, you cannot. You cannot rub them on the wrong side. You cannot just start arguing with them that CPC doesn't apply. Therefore, I'm not supposed to argue in the manner you want me to. This is not the right way of advocacy. Advocacy is not to fight with the arbitrator. You have to be on their right side. Talk in the language they want to hear. Therefore, it is very important that, and again, there is another very interesting aspect. In international arbitration, you may have arbitrators coming from different legal cultures. One may be from civil law culture, another may be from common law culture, third may be from Sharia law culture. You may have people from different jurisdictions in a sense that they have their whole trade as per their own domestic legislations, own domestic procedural rules, procedures. So therefore, you must know the tribunal. As I said, you must know the audience, you must know the tribunal. You must know about their training. That's why it's also very important, before you go for arbitration hearing, or rather before you start arbitration, you should and you must do a proper due diligence. Know more and more about the arbitrators before whom you are going to appear. So it is very, very important. Now, this is generally asked, can you give us tips for effective advocacy in arbitration? I would say 4 things are the key for effective advocacy. One is effective preparation. And second is written advocacy. Third is oral advocacy. Fourth is advocacy ethics. Now, I'll repeat myself. Effective preparation, written advocacy, oral advocacy, and advocacy ethics. These are the 4 key attributes which is needed. Now, what is effective advocacy or effective preparation? Actually, effective advocacy requires and demands thorough preparation. Nothing happens without thorough preparation on the part of the arbitration lawyer. That's why I said in a while ago that you should know your case. I said in short KYC. It is a very, this is one expression every day you get to hear from your banker. Know your case is the key. Now, that doesn't mean that you should not know the case of the other side, but you must know your case. And when I say you know your case in a manner that you have answer to the other side's case as well. I have seen in many arbitrations in both my avatars or capacities as arbitration counsel as well as arbitrator, that sometimes lawyers are only concerned with, they talk about only their case, whatever the case they think is their case, whatever they have pleaded. They would not understand other side's response to their case, their opposition to their case. And this is something very, very damaging for any lawyer. Now, what is good preparation? I talked about effective preparation as the first key. The underlying rationale for extensive preparation is, how can an arbitration counsel effectively advocate their case if they do not know what their case is to begin with? And therefore, what you should know first, mastery over the contract. Arbitration is essentially about contract. So, mastery over the contract. Mastery over the facts. What do you mean by facts? Facts, apart from knowing the contract, you should know what all transpired between the parties. You should be in a position to, and in fact, in arbitration, and a good arbitration lawyer recreates the entire transaction before the tribunal. So you should know all the facts. Knowing facts means knowing the documents, knowing the evidence, that is documentary evidence, knowing the oral evidence. So therefore, you have to know the contract, you have to know the facts, and you must have mastery over the law. Apart from these 3, there is another requirement, that is, you must know the arbitration law as well. And in fact, one survey I was reading once, and it says that the clients would not go to a lawyer who otherwise knows the subject, who knows the fact, who knows the law relating to that, he knows the industry. But if he does not know, he's not well versed with the arbitration proceedings, clients will not go to them. Therefore, it is very important for anybody who wants to pursue arbitration as a career that you should know arbitration as a subject. And when I say arbitration as a subject, I also give emphasis that you should also know international best practices. And I have seen lots of people asking this question. I'm not doing international arbitration. I do not have international arbitration cases. Clients are not coming with international arbitration disputes in international arbitrations. So, am I supposed to know international best practices when it comes to arbitration? Answer is you must. You must know international best practices. You must know relevant institutional rules such as ICC, CIAC, HKIC, SCC, institutional rules. Apart from this, you should also know the soft laws. What are soft laws? Like the Chartered Institute of Arbitrators UK has a lot of protocols, a lot of guidelines, which is called soft laws, which talks about many important aspects of arbitration. How to write arbitration award, how to award interest, how to talk about cost, what are ethical issues involved in arbitration, so on and so forth. Now, another important source for soft law is IBA, International Bar Association. Now, IBA has very important and relevant soft laws, such as IBA guidelines on evidence. And in fact, one of their guideline was incorporated almost as it is in your Arbitration and Conciliation Act 1996. That is your Schedule 5, Schedule 7, which you see here on conflict of interest. This is all essentially IBA guidelines on conflict of interest. So there are various other such credible institutions which would come out with such soft law. You should keep this in mind. Another thing which I said, I would tell you that when I said that you should have gone through the contract, what is that really mean? Knowing contract or mastery over the contract is the starting point for any arbitration lawyer. As I said earlier, that arbitration is essentially about contractual disputes. So therefore, you must, in fact, your section 28 of Arbitration and Conciliation Act also talk about knowing of, not only knowing of contract between the parties. It says that arbitrator will decide the disputes as per the contract between the parties. So if arbitrator wanders beyond the contract, award will be set aside. Therefore, it is very important. Your rights and obligations would arise from the contract. So therefore, what you need to do is you have to have detailed and attentive, you must have detailed and attentive reading of the subject contract. Secondly, all provisions, including the preambular text, must be read and understood. And active reading is important. You highlight wherever you find it is important. Scribble in comments. Look for connections between various clauses. I'll tell you, I do lots of construction arbitration as a lawyer as well as arbitrator. My understanding of construction law today is primarily because of the fact that from day one, when I started my practice as construction lawyer, I used to go through the contracts, which are construction contracts, runs into thousands of pages. I would go through every single clause and try to understand, because understand one thing, these contracts are, these standard forms of contract are prepared by seasoned professionals who know the industry, who know how risks between the parties are allocated. Therefore, knowing the contract is very, very important. And if a standard form is used, if any standard form of contract is used, like for construction contract, if fitting form is used, then reference to commentaries on such form is very, very important because it gives you wider contextual understanding. So whenever you have extended forms and if you find any commentary written on that, you must read the commentary also so that you understand from the experiences of others and if there are any case laws. In any case laws on particular provision of a particular extended form is again going to help you immensely. Next is mastery over the facts, as I said earlier. Now, best way to have mastery over fact is to prepare chronological list of dates and events. So, every construction arbitration, a professional lawyer or any arbitration lawyer, first thing you should do is you should prepare a chronological list of dates and events. This is very, very important, and particularly for complex arbitrations. This is the starting point. And arrange and you have to keep this, you have to update it. You prepared a list of documents, list of dates and events based on whatever documents you had. Now, other side will file their documents. Now you have to again update your list of dates and events. And again, it should be in a chronological manner. So you may have to insert dates in between your dates. You may go for filing of subsequent pleadings. Again, you have more documents. You may have discovery, where again, further documents come. You may have evidence at the evidentiary stage, again, further documents come. During cross-examination also, certain documents are brought on record. So you have to prepare this chronological list of dates and events, and you have to update it. And you can even share this list of dates and events with the arbitral tribunal, and lots of arbitral tribunals prepare their own list of dates and events, or they will insist that you should prepare such list of dates of events and give it to them. And particularly for complex matters, it is very important. What happens? Suppose you are making submissions, oral submissions, and you are referring to a couple of documents. Tribunal may ask you, what happened between these two dates, which are mentioned in those two documents which you are referring to. Now, you have documents, you have the file which is running into thousands and thousands and lakhs of, sometimes lakhs of pages. It's not humanly possible to remember every single date, every single document. So how do you answer this? If you have list of dates and events, you have read two documents, take out that, see what are the developments which have taken place between those two dates. You have to just refer to the list of dates and events. And when you prepare, and this is one of my suggestions would be that whenever a client comes to me or a briefing counsel comes to me, I tell them that first of all, you should prepare a chronological list of dates and events, put documents in that particular sequence, and thereafter prepare one executive summary that is about what is the understanding of the client about his case. And thereafter, when they have done it, they would have done it, ask them to prepare compile documents issue-wise. Yes, one may have a question that issues are not yet framed in that sense. That happens much later after submission of exchange of pleadings. Issue means, suppose case revolves around delay in construction, delay in supply. You ask the client or the briefing counsel to prepare documents on delay. Suppose you have a claim or you have dispute between the parties on quantification. Delay obviously leads to loss. That's why these parties are in dispute. Now on quantification, you may have your own documents, so prepare those in that particular manner. Whole idea is, and in fact, Mr. Chatrath was talking to me couple of days back, and he said it is sometimes very difficult for lawyers to understand how to really digest the facts, because in complex arbitrations or construction arbitrations, these are fact heavy, issues heavy. How to really have mastery over the facts. This can be achieved, mastery of facts. You can have mastery over facts if you know how to do it. Best way to do it is start with preparation of chronological list of dates and events. Put documents in that order. Keep updating this. That is the starting point. Second important thing is, there is something called case theory. Once you have collected the documents, you should prepare your case theory. What is case theory? Case theory is like you are appearing before a court of law and judge is asking you, tell us what is the dispute between the parties. 1. What is your case? 2. And 3, how are you correct? How are you right? These are the 3 things which constitutes case theory. What is the dispute between the parties? What is your position? And 3, how are you right? If you understand these 3 aspects, you take it from me, you can win any case, or you can put across your points in a most effective manner, whether it is court of law or it is an arbitration proceeding. So before you go to court, before you start writing your pleading, or before you go and make your oral submissions, first thing you should know is what is the real disputes? What are the real disputes between the parties? Once you understand that, note it down. Real disputes. Second, what is your position? What is your case? Write about it. And 3, why are you right? Why are you correct? If you are able to do this, you can summarize your whole case maybe in half a page, 1 paragraph or 2 paragraphs. Or you can even be ready to argue the case, gist of the case before any tribunal or any court of law in few minutes, 4 minutes, 3 minutes, 5 minutes, like you do in Supreme Court in SLP. Yes, when you are going for final submissions, oral submissions, lengthy submissions, there you will be you'll be inviting the attention of the tribunal to various documents and evidences and all of this. But knowing the case theory from day 1 is very, very important. And I must repeat myself. Case theory is about knowing 3 things. 1, what is the dispute between the parties? 2, what is your case? And 3, how are you right? And if you can do it, your whole case preparation will be focused, and you will be able to appreciate the other side's case, and you'll be able to persuade the tribunal in much better way. Next thing is mastery over law. Now, when I said case theory cannot be complete without knowing or without having mastery over the law. So in arbitration practice, is not only supposed to know the facts, he's also supposed to know the law applicable to facts of his case or her case. That's very, very important. Now, therefore, having mastery over law is important. Do your research well, know all relevant judgments on the disputes in hand, do extensive research. This is very, very important. And if you have done good mastery over the laws, you can understand the strength and weaknesses of your case. And this reminds me about one important thing about arbitration advocacy. that from the day when clients approach you, very first day, you should have a frank discussion with your client on the strategy aspect of the whole case. What is the strategy? In other words, to start with, what is the objective behind going for this arbitration? What is that your client wants to achieve out of it? Is he really agreed? Or he feels that I'm not aggrieved, but I want to just drag it on? Does he really want to continue good relationship with the other side? What is the objective a client has? That's very, very important. So you have to invest good amount of time in understanding this strategy. And now when we talk about a strategy, that is the point of time when you have to tell your client whether he should or she should. What is their strength and weaknesses? What are the strengths and weaknesses of his case? Is it a meritorious case? Should he really pursue it? What are the chances of winning? Obviously, you would not be able to understand entire strengths and weaknesses, but you will have some idea about it. And I must tell you, when a particular case comes to you, your first reaction to the case may be something, but after case runs its course, or you are in the process of the arbitration, it will take different, it will have different kind of, it will give you different kind of perception. Initially, you might have thought that my case is very weak. With the more and more document coming on the record, other side's position coming on the record, maybe after going through other side's document on record, you may find that your case is not that weak. And then gradually, it is a continuous process. Arbitration is a continuous process, that whole proceeding. You are doing research on this. You are updating yourself with the latest laws of the subject. So all of this, so your perception may be something on the day one, but your perception at some later point of time may be very different. But when I talk about a strategy, I must tell you that on the day one, if you have got experience in that subject, you will have some idea about the strength or weaknesses of the case. You must discuss all of this very frankly with the client, and you can tell them, case will progress, we'll see how far it goes, we can work on this. But this is my today's understanding of your case. You should be frank with your client. You should have courage to be frank with your client. Now, another thing which is important is, as I told you earlier, now with the shift from oral advocacy to written advocacy, you should, therefore, we must talk about in a bit about written advocacy case. The tribunal's first impression about your case and about you as a lawyer would be through the initial submissions or initial pleadings. I'll tell you, there is one arbitration proceeding going on, and I'm the arbitrator. When I saw the statement of claim, it was running into hundreds of pages, almost 200 pages. I'm talking about the pleading part of it. But it was very difficult to really comprehend what the case was all about, because lawyer had not talked about the case theory in the beginning. So in order to understand the case of that party, you were supposed to go through entire almost 200 pages. And even then you may have problems if it is not written well. Therefore, it is very important that you must have, and so as a tribunal, I will carry certain impression about the lawyer who would have drafted. So therefore, it is very important that you understand understand about written advocacy. Now, what you are supposed to do in written advocacy is all issues and points. Issues means relevant issues should be covered, because oral submissions may have some issue with time. In international arbitration, generally, we have something called chess clock method, in which both sides will be given X number of hours to complete their case. So that includes opening submission, examination in chief, cross-examination, and your oral arguments or final argument, whatever you call it. Now, you have to go by clock. You have to go by the watch. Therefore, you may not have enough time to really cover everything what you wanted to cover. Even if it in the domestic arbitration situation, you may not have enough time to cover everything which you want. Therefore, if you have drafted your submissions well, if you have drafted your post-hearing brief or written argument well, you will be able to convey your point. You can, in the oral submission, you can tell the judge, that the arbitrator, that I have made certain submissions. For the rest, tribunal may kindly have a look at my written argument. So therefore, written argument, you have to cover all the issues, all the points. And this is again, what is good drafting? What is good drafting? Now, good structured drafting helps the tribunal to follow your arguments. So what you are supposed to do is, you have to be a good storyteller, but you should be a short storyteller. Your story should be short. It should be pregnant, it should be short, it should be crisp. And in starting the drafting process, the advocate must reflect on 3 questions. 1, what relief does my client want? You have to reflect on these 3 issues before you draft. What relief does my client want? 2, for what reason such relief be granted? And 3rd, can the reasons be supported by fact and law? I repeat myself. Before you start drafting, you should reflect on, think over these 3 things. 1, what relief does my client want? Note it down. 2, for what reason should such relief be granted? And 3rd, can the reasons be supported by fact and law? This is very, very important. You write it. And another important thing is how you write your SOC, SOD, pleadings, written arguments. You should not involve yourself in too much of lawyerism, that it is stated that, and so forth. It should be talkative English. It should be simply about conversational style of writing. Small paragraphs, small sentences. Sentences should not be more than 20 words. Small sentences, small paragraphs covering 1 or 2 points. Not 1 point, 1 paragraph, I would say the best way of doing it. Write in a proper sequence. So these are typical ways how it is done, and it should be done. Because end of the day, whole idea is to tell the tribunal what is your case all about. So you justify your case theory. In order to do that, you have to do the hand holding of the tribunal. Now, it is very important, and this is the practice now even being followed by Supreme Courts while writing its judgments. So you can take lessons from them. Lots of, if you see good briefing, good drafting in any particular arbitration, people have headings, subheadings. So my suggestion is, before you start writing detailed SOC or SOD or your written, prepare one index or in other words, table of content. What is that you want to write? What is that you want to write in your entire pleading? It is just table of content like any book has. And then, so you have headings, you have subheadings. And under them, write a small paragraphs, a small sentences. These are very, very important. Simple English. You're not supposed to write complex English. You should not ask the tribunal to consult dictionaries and all. That's not appropriate. This is not the arbitration, is not a forum where you are supposed to show your other skills. And cross-referencing of documents in your pleadings and your in written arguments. Very, very important. Cross-referencing of documents. This is, and when you file your documents in a chronological manner. And at later stage, with the permission of the tribunal, if you want, you can prepare the documents issue-wise and give it to the tribunal. I'll give lots of emphasis on one thing which I follow, that whenever we are at the stage of final arguments, I encourage all of you to give a skeleton argument to the tribunal. Suppose you are representing the respondent. Right in the beginning, issue number 1, claimant's position, and write claimant's position in bullet points. One sentence, bullet points in one sentence. This is claimant's position. Claimant, in that sentence, claimant relies upon this document, give the reference of the document, and claimant relies upon the judgment, cite the judgment. So in one paragraph, small paragraph, you have written what claimant says about its case or its case. Now, what is your position on that? Again, respondent's position. Again, in bullet point, you say my position is 1, 2, 3, 4, 5. These are the documents I refer to. These are the cross-examinations I refer. This is the judgment I refer. This is the academic paper I refer to. Write it in bullet point. It works wonders. And other ways of doing it is that if suppose in construction arbitration, very big construction arbitration, I have got a foreign expert on delay. Now there are, it is about a thermal power plant. What I have done is I have prepared videos on those contentious issue, which I show to the tribunal. It really helps a lot. Photographs really helps a lot. Tables, putting things in tabular form, it really helps a lot. Therefore, these are the ways, and this is never-ending process. You have to evolve you have to evolve, and you have to compete with yourself in not only in knowing the law in a better way every day, but also in how to present your case, how to prepare notes, how to prepare notes of arguments, how to prepare skeleton arguments, how to prepare written briefs, post hearing briefs. And so far as oral advocacy is concerned, I'll tell you one thing you must keep in mind. We have 3 minutes left now. Oral advocacy, when it comes to oral advocacy, theatrics does not work in arbitration. Here, everybody is sitting in a comfortable atmosphere. Everybody is seated on chairs. No gesturing. Put across your points. Be cool, be composed. And never use harsh words. This I have learned in my experience. Never use harsh words against the tribunal or against other side lawyer or other side client, because tribunal will not take it in good taste. It never, and even during cross-examination, never be harsh with the witness. Tribunals will not like it. So this is something you must keep in mind. And if you keep the essentials of advocacy ethics, as I said earlier, do not mislead the tribunal, be humble to the tribunal, remain credible before the arbitral tribunal. These are the things which are really going to help you in big way. And this is because, as I said, arbitration is a one-stop shop. You have to give your 100%. Be prepared, be humble, and win cases for your client. Thank you very much. It is 7 o'clock. Yes, Mr. Chatrath, any questions?
Haji sir.
Yes.
Since we have taken this session in English, I will just summarize in Hindi. What will be mantras you can tell to the persons who are watching and would like to learn in Hindi? And since I've seen the entire session as such and heard that it's not simplicity, I would say, restricted to the advocacy skills of arbitration. One who has heard this is find that it is all related wherever advocacy is trying to do. Oral skills, making of notes. So we will not restrict. जब आपसे हम हिंदी में बोलते हैं कि आप बताएं, तो ये सारा सेशन अगर आप इनका सार या सारांश निकालना हो तो हिंदी में आपके अकॉर्डिंगली क्या मूल मंत्र रहेंगे एडवोकेसी को इम्प्रूव करने के लिए?
देखिए, जैसा कि मैंने कहा कि सबसे इंपॉर्टेंट बात यह है कि आर्बिट्रेटर्स भी इंसान हैं, पहली बात तो ये बात दिमाग में रखनी चाहिए कि हमें उनको एनवाय नहीं करना चाहिए. दैट डज नॉट मीन कि आप अपनी बात ना कहें, अपनी बात जरूर कहें, लेकिन उनको आपको बेवजह एनवाय करने की जरूरत नहीं. जहां तक केस के एडवोकेसी एज ए होल की मैं अगर बात करूं तो फैक्ट्स की मास्टरी, जिसका मतलब होता है कि कॉन्ट्रैक्ट की मास्टरी, डॉक्यूमेंट्स की मास्टरी. और डॉक्यूमेंट्स की मास्टरी सबसे महत्वपूर्ण बात है जो डिफिकल्ट होती है. उसके लिए क्रोनोलॉजिकल लिस्ट ऑफ डेट्स एंड इवेंट्स बनाना, उस हिसाब से डॉक्यूमेंट्स को अरेंज करना बड़ा इंपॉर्टेंट महत्वपूर्ण होता है. उससे आपको पूरा पता चलता है कि ये पूरा का पूरा एक ट्रांजैक्शन हुआ कैसे. तो ये चीज पहले तो पता करना बड़ा जरूरी है. उसके बाद आपको पता होना चाहिए, जब आपने डॉक्यूमेंट्स, कॉन्ट्रैक्ट पढ़े, डॉक्यूमेंट्स पढ़े, तो आपको ये पता चल जाता है कि डिस्प्यूट क्या है. उसके बाद डिस्प्यूट पता चल गया, फैक्ट पता चल गया, फिर आपको लॉ पता होना चाहिए. लॉ के लिए फिर आपको थोड़ा रिसर्च करनी पड़ेगी, आपको फैक्ट्स की मास्टरी करनी पड़ेगी, लॉ की मास्टरी करनी पड़ेगी, और आर्बिट्रेशन प्रोसीजर्स की भी मास्टरी रखनी पड़ेगी। ये 3 चीज है। तो लॉ की मास्टरी कर लीजिए, फैक्ट्स की मास्टरी करिए, उसके बाद पहला इंपॉर्टेंट चीज होता है केस थियरी बनाइए। जो मैंने कहा था कि इस केस में डिस्प्यूट क्या है, मेरा केस क्या है, और मैं कैसे सही हूं, ये 3 बात आपको समझनी चाहिए। उसके बाद ड्राफ्टिंग करने के लिए एक टेबल ऑफ कंटेंट पहले बनाएं, जिसमें हेडिंग्स और सब हेडिंग्स लिखें, और उसके बाद आप प्रॉपर ड्राफ्टिंग करने बैठे। छोटे छोटे सेंटेंसेस लिखें, छोटे छोटे पैराग्राफ्स हों, हेडिंग सब हेडिंग्स में लिखें। ऐसे करके आप और साथ में डॉक्यूमेंट्स लगाएं, हर एक प्लीटिंग में डॉक्यूमेंट्स को रेफर करते चले, क्रॉस रेफरेंसिंग करते चले। जब आप आर्गुमेंट्स के स्टेज पे आते हैं, उस वक्त आपको यह करना चाहिए कि स्केलेटन आर्गुमेंट जरूर बनाना चाहिए कि भाई क्लेमेंट का केस क्या है, बुलेट पॉइंट में लिख दिया, एक एक लाइन में उनका ये 5, 7, 8 लाइन में, 10 लाइन में उसकी केस ये आ जाती है। एक इशू पे उन्होंने किस डॉक्यूमेंट को रेफर करा वो उसमें लिख दीजिए उसी सेंटेंस में, और उन्होंने किस जजमेंट को रेफर किया उसके नीचे रिस्पोंडेंट्स रिस्पॉन्स, आप अपनी बात लिख दीजिए 10 लाइन में, 5 लाइन में, बुलेट पॉइंट। डॉक्यूमेंट को क्रॉस रेफरेंस कर दीजिए, अपने जजमेंट से रेफरेंस कर दीजिए। जब आप बहस करने जाते हैं, देखिए ये मान के बैठ जाना कि सारे आर्बिट्रेटर्स पूरा फाइल पढ़ के आते हैं, उनको सारी फैक्ट्स की जानकारी है, उनको फैक्ट्स की मास्टरी है जैसे आपको है, ऐसा होता नहीं है। यस, गुड आर्बिट्रेटर would like to understand your case, and therefore they would have gone through your files. But in India, I must tell you, in my experience as arbitrator, as lawyer, I have seen that invariably arbitrators would not have gone through your whole case thoroughly. Yes, if you have given submitted your skeleton argument, I'm sorry, तो वो जो skeleton argument अगर आपने दिया भी है तो उसको लोग पढ़ के आएंगे, तो उससे कुछ ब्रॉड आइडिया रहता है। और वो जो स्केलेटन आर्गुमेंट जब आप देते हैं, तो जब आप बहस करते हैं तो उसी पे आर्बिट्रेटर नोट कर रहे होते हैं, उनके सामने डेट्स आपने बना के दिए होते हैं, एक छोटा सा लिस्ट ऑफ डेट अगर आपको लगता है जरूरी है तो वो बना दिया, नहीं तो आपके नोट से जो बातें निकलती हैं। तो जिस तरीके से आप बहस करना चाहते हैं, जिस तरीके से वो बातें इश्यूज को कवर करती हैं, वो एक बढ़िया स्केलेटन आर्गुमेंट बनाना सीखिए। और उसके बाद जो आप बहस करेंगे, रिटर्न वो स्केलेटन आर्गुमेंट साथ रख के और आर्बिट्रेटर भी साथ रखेंगे, तो आप समझे कि आपका बहुत बड़ा काम हो जाता है। आर्बिट्रेटर को आप अपना केस समझा पाते हैं, और उसके बाद जब पोस्ट हियरिंग ब्रीफ देने की अगर नौबत आई कि नहीं, उसके अलावा अब दूसरी साइड का भी आर्गुमेंट हो गया, रिजॉइंडर आर्गुमेंट भी हो गया, बाद में एक और देना है, तो वहां भी कोशिश करिए ज्यादा से ज्यादा बुलेट पॉइंट में लिख के दीजिए। ये जो पूरा एक लंबा सा प्लीडिंग की तरह इट इज रॉन्ग, डिनाइड, ये वो करके जो आप 20 पेज, 40 पेज, 50 पेज, 100 पेज का रिटर्न आर्गुमेंट देते हैं, उन चीजों से बचना चाहिए। लोगों के पास उतना टाइम नहीं होता पढ़ने का, तो इन सब चीजों को अप्रिशिएट करना चाहिए। और आर्बिट्रेटर के सामने सिर्फ प्रॉब्लम देने से काम नहीं बनेगा। मेरा केस ये है, बाकी आप समझिए, इस केस में ये प्रॉब्लम है, इसका क्या जवाब है मुझे भी नहीं मालूम, आपको भी नहीं मालूम, आप समझिए, फिर आप परेशानी में पड़िए। आप सिर्फ प्रॉब्लम देने के लिए नहीं है, आर्बिट्रेटर की हैंड होल्डिंग करनी पड़ेगी, उनको हाथ पकड़िए, वो आपकी तरफ देखें। जब वो किसी परेशानी में हो, किसी चीज को समझने की परेशानी में हो, तो आपके तरफ पहले देखें, अदर साइड लॉयर की तरफ पहले ना देखें। क्योंकि आपने अपनी केस की तैयारी अच्छी की है, आपने उनका ट्रस्ट अर्न किया है, आप हम्बल रहे हैं, तो इन सब चीजों को मिला के ही एक एडवोकेसी स्किल सेट बनती है। तो इन चीजों में आप ध्यान दें, शुरू से अच्छा कैसे बोलना है, अच्छा स्टोरी टेलिंग कैसे करना है, अच्छा ड्राफ्टिंग कैसे करना है, इसके स्किल्स कैसे। मैं एक बात बताऊं, मैंने बड़े सारे सीनियर लॉयर्स को देखा है कि उनकी एक एक सेंटेंस, एक एक पैराग्राफ की होती, ये सब इतनी एनोइंग है कि ट्रिब्यूनल पढ़ के समझने की बात तो छोड़िए, उठा के फाइल फेंक देगा। एंड यू हैव टू ब्लेम योरसेल्फ। एक सेंटेंस में 20 वर्ड से ज्यादा नहीं होने चाहिए। 20 नहीं होगा, 22 हो जाएगा, 24 हो जाएगा, एक पैराग्राफ थोड़ी ना हो सकता। इसका मतलब है आपको ड्राफ्टिंग नहीं आती। और ये सब कन्वर्सेशनल स्टाइल में होना चाहिए। ये नहीं कि दैट इट इज स्टेटेड दैट इट इज इनकम्बेंट, इट इज इंपॉर्टेंट टू से दिस एंड ऑल ऑफ दिस। सीधा शुरू करिए, जैसे बात करते हैं हम, आप उसी तरह से अंग्रेजी में उस तरीके से लिखिए पैराग्राफ, छोटे छोटे पैराग्राफ, छोटे छोटे सेंटेंस, हेडिंग बढ़िया। और ये सब आप एसओसी में भी करिए, एसओडी में भी करिए, सब जगह करिए। अपने केस को बेहतर तरीके से कैसे समझना और समझाना और ट्रिब्यूनल का ट्रस्ट विन करना, यही तो है एडवोकेसी, आर्बिट्रेशन एडवोकेसी। इसी में हमें मास्टरी करनी होती है। और ये एक करने से होती है, ये सिर्फ सुनने से नहीं होगा, ये करने से होगा। और ये नेवर एंडिंग प्रोसेस है। जितना करते जाएंगे उतना आपका ये तरीका रिफाइंड होता जाएगा। आप कहेंगे कि नहीं मैंने सीख तो लिया, मैं कर रहा हूं, कर लिया, 5-10 केस में कर लिया। मैं बताता हूं 10 केस में करेंगे ना तो 11वां केस उससे बेहतर इसलिए हो जाएगा कि अब आपका नोट छोटा होना शुरू हो जाएगा। जैसे जैसे आपका एक्सपीरियंस बढ़ता जाएगा, आपका आर्ट ऑफ रिटन एडवोकेसी डेवलप होता जाएगा, आपके नोट्स छोटे होते जाएंगे, आपके प्लीडिंग्स छोटे होते चले जाएंगे। ये सब है तरीका। लेकिन दिस इज डन, ये लर्निंग बाय डूइंग वाली बात है। तो इसको करने की कोशिश करनी चाहिए। और आपको कभी आर्बिट्रेटर को एनवाय नहीं करना चाहिए, उनकी हैंड होल्डिंग करनी चाहिए। यही है आर्बिट्रेशन एडवोकेसी।
सर इंग्लिश में तो आपने बता ही दिया था, अब हिंदी में पूछ लेते हैं। वही वाला सवाल जो पहले जब सेशन की बातचीत चलने लगी कि 4 पेज होते हैं, उनको क्रक्स कैसे निकालना शुरू किया जाए। हाउ डू यू स्किम दी मिल्क एंड गेट दी whip ऑफ द क्रीम।
देखिए होता क्या है कि मैं थोड़े से कॉम्प्लेक्स आर्बिट्रेशन की बात बताऊं या कॉम्प्लेक्स ट्रांजैक्शंस की बात बताऊं। होता क्या है, मैं कंस्ट्रक्शन आर्बिट्रेशन की बात जैसे बोलूं। अब एक प्रोजेक्ट है, कोई थर्मल पावर प्लांट बन रहा है सपोज कर। अब वो 3 साल तक बना है। हर एक दिन हजारों सैकड़ों डॉक्यूमेंट्स बन रहे हैं प्रोजेक्ट से, प्रोजेक्ट साइट से हेड ऑफिस जा रहे हैं, वहां से कॉन्ट्रैक्ट मैनेजर लिख रहा है, प्रोजेक्ट मैनेजर लिख रहा है, एक साइट दूसरे साइट को लिख रहा है। और ये सारी चीजें 4-4 साल तक चली हैं। डायग्राम्स आ रहे हैं, फोटोग्राफ्स आ रहे हैं, अब तो वीडियोग्राफ्स भी आती है। अब डेली प्रोग्रेस रिपोर्ट जाती है, वीकली प्रोग्रेस रिपोर्ट जाती है, कई दफा मंथली प्रोग्रेस रिपोर्ट जाती है, मिनट्स ऑफ मीटिंग्स होते हैं। अब इन सबों की मास्टरी करनी कैसे? पहले तो इसका तरीका यह होता है कि सबसे पहले एक बार क्लाइंट को बोलिए कि वो आपके पास आके बैठे, वो बोले कि भी वो बताएं आपको कि उनका प्रोजेक्ट क्या है, उनका डिस्प्यूट क्या है, उनकी बातों को सुनिए। और उससे पहले अगर संभव हो तो क्लाइंट को बोलिए कि आप अपना एक एग्जीक्यूटिव समरी बना के भेजिए। हर एक डिपार्टमेंट को, हर एक क्लाइंट को, हर एक कॉन्ट्रैक्टर को, हर एक एम्प्लॉयर के यहाँ लोग हैं जिनको अपने केस के बारे में एग्जीक्यूटिव समरी लिखना आता है कि 1 पेज, 2 पेज में, 3 पेज में वो बता देंगे कि ये मेरा पूरा केस क्या है। वहां से शुरू करिए। वो जब आपके पास आ जाए तो उसके बाद क्लाइंट से बात करिएगा तो आपकी बेटर अंडरस्टैंडिंग होगी। उससे आपको ये पता चल जाएगा कि ये प्रोजेक्ट क्या था, ये ट्रांजैक्शन क्या था और इनका डिस्प्यूट किस बात को लेके है, और हमारा क्लाइंट क्या कह रहा है और दूसरा साइड क्लाइंट क्या कह रहा है। अब उसके बाद आपको सबसे इंपॉर्टेंट है कि डॉक्यूमेंट और एविडेंस गैदरिंग करना। वो कैसे होगा? वो जितने रेलेवेंट डॉक्यूमेंट हैं वो सारे के सारे डॉक्यूमेंट्स निकाले जाने चाहिए। क्लाइंट्स के यहां आपके वकील जाके बैठे या क्लाइंट्स के लोग आपके यहां आके बैठे, सारे डॉक्यूमेंट्स को इकट्ठा करें। और जो मैंने पहले कहा, क्रोनोलॉजिकल लिस्ट ऑफ डेट एंड इवेंट बनाएं। जब उसको आप पढ़ेंगे तो आपको पता चल जाएगा कि यह प्रोजेक्ट हुआ कैसे है, इस प्रोजेक्ट में डिस्प्यूट क्या क्या हुआ है, और डिस्प्यूट में दोनों साइड का कहना क्या है। क्योंकि तब तक बहुत चीजें हो चुकी होती हैं। उसके आधार पर आप अपना एक केस थ्योरी बनाइए कि इस केस में डिस्प्यूट क्या है, इस केस में, इस मसले पे, इस डिस्प्यूट पे हमारा क्या कहना है, और हम क्यों करेक्ट है। उसके लिए क्या करना है कि कॉन्ट्रैक्ट के प्रोविजन से उसको भी पढ़ने हैं, लॉ को भी पढ़ने, उनको मिला के आप पढ़िए तो आपकी केस थ्योरी बन जाएगी। केस थ्योरी बन गई, इसका मतलब आप हजारों हजार पेजेस के डॉक्यूमेंट्स वाले केस को आपने आधे पेज में लिखना समझ लिया और उसको 2 मिनट, 1 मिनट, 3 मिनट के अंदर किसी को भी बता सकते हैं कि ये 4 साल का पूरा ट्रांजैक्शन और इसका डिस्प्यूट क्या है, कौन सही है कौन गलत है। यही है इसका मूल मंत्र।
नेक्स्ट सवाल, चलो हमारे जैसे और आप जैसे तो बहुत ही हैं। अब जैसे ये जजमेंट्स आती हैं, जजमेंट्स का इंटरप्ले प्लीडिंग्स में और वैसे ड्यूरिंग द कोर्स ऑफ आर्गुमेंट को कैसे इस्तेमाल किया जाए।
देखिए, जजमेंट्स को आप अपने प्लीडिंग्स में नहीं लिखते, ना लिखना चाहिए, लेकिन जब मैंने कहा ना कि केस थ्योरी कैसे बनेगी, केस थ्योरी तब तक आप नहीं बना सकते जब तक कि सारे रेलेवेंट जजमेंट्स आपको नहीं मालूम, लीगल प्रिंसिपल्स आपको नहीं मालूम जो उस डिस्प्यूट को कवर करता हो। तो जजमेंट्स आपको पता चल गए, केस थ्योरी मालूम चल गई, उसी तरीके से अब आपका ऑब्जेक्टिव है कि मुझे अब मेरी ड्राफ्टिंग कैसे बनानी है। उसमें आपको अब क्या करना है कि जजमेंट आप लिखेंगे नहीं, लेकिन एसओसी में या जो भी आपके एसओडी है उसमें जो लीगल प्रोपोजिशंस है, लीगल रेशियो है किसी जजमेंट्स के, उसको आप बिना जजमेंट को लिखे आपके केस को वो कैसे कवर करता है उसको आपको लिखना है। तो ये मानना कि फैक्ट अलग है, लॉ अलग है और केस थ्योरी कोई तीसरी चीज है, ऐसी बात नहीं है। फैक्ट को जानना, लॉ को जानना, जब हम लॉ को जानने की बात करते हैं तो जो स्टैट्यूटरी प्रोविजंस है उसको जानना और जो केस लॉज है उसको जानना, और उसमें भी अपने आप को सिर्फ इंडियन केसेस तक कन्फाइन ना करें। आप कॉमर्शियल लॉ में, कंस्ट्रक्शन लॉ में इनवेरिएबली हम फॉरेन जुरिसडिक्शंस में जो डेवलपमेंट्स होती हैं, जो जजमेंट्स होती हैं, उनको फॉलो करते हैं, उनको लिखते हैं और इंडियन कोर्ट्स बहुत लिबरली उनको रेफर करती है। तो आपको इन चीजों के बारे में अवेयरनेस होनी चाहिए कि ओवरऑल डेवलपमेंट अक्रॉस द ग्लोब इन कॉमन लॉ जुरिसडिक्शंस इन इश्यूज पे क्या हो रहा है। तो ये जजमेंट कोई अलग चीज नहीं है। लॉ जानने का मतलब हो गया कि आपको स्टैट्यूटरी प्रोविजंस और लीगल प्रोविजंस, अब जैसे कि कंस्ट्रक्शन लॉ अगर आप कर रहे हैं तो आपको ये भी पता होना चाहिए कि कंस्ट्रक्शन लॉ क्या है और फिर कंस्ट्रक्शन लॉ के बारे में जानकारी भी होनी चाहिए। यही
इसी से आगे सवाल एक और लेते हैं। जब हमने जजमेंट्स का भी बोल दिया, बल्कि ये पहला सवाल इससे पहले आना चाहिए था, जो ये इंटरट्वाइनिंग ऑफ द सेक्शंस होते हैं कि ये कॉन्ट्रैक्ट एक्ट का और कॉन्ट्रैक्ट का जब पढ़ते हुए या उसके अंदर हम लिमिटेशन एक्ट को, इन सब का इंटरप्ले जब हमने ड्राफ्ट बनाना है एज अ क्लेमेंट, एज अ रिस्पोंडेंट, एज अ पिटिशनर, एज अ प्लेंटिफ, एज अ डिफेंडेंट, एज अ रिस्पोंडेंट, तब इनका इंटरप्ले दिमाग में, वो कहते हैं डॉक्ट्रिन ऑफ रिवर्स थिंकिंग एंड डॉक्ट्रिन ऑफ फनलिंग ऑफ थॉट्स जो शुरू करते होते हैं। तो आप यंगस्टर्स को कैसे गाइड करेंगे कि ये इंटरप्ले ऑफ डिफरेंट सेक्शंस को प्लीडिंग्स के टाइम में अपने दिमाग में कैसे सोचना चाहिए?
देखिए, ऐसा है कि ड्राफ्टिंग करने के लिए, ये सब लीगल ड्राफ्टिंग, इसको करने के लिए आप सबसे पहले जो बात होती है ना कि एक लॉयर ड्राफ्ट कर रहा है ना, या टेक्नोलीगल आदमी ड्राफ्ट कर रहा है, तो ये माना जाता है कि उनको बेसिक लॉज जो फर्स्ट प्रिंसिपल्स हैं, मोटे तौर पे उन्होंने लॉ स्कूल में पढ़ा हुआ है और एक्सपीरियंस से काम करते करते सीख रहे हैं, तो उनको उन बातों की जानकारी रहती है और रहनी चाहिए। आप कॉमर्शियल लॉ की बात करें, कंस्ट्रक्शन लॉ की बात करें, तो 3-4 स्टैट्यूट्स हैं जिसको आपको पढ़ने आना चाहिए, आपको उसके बारे में पता होना चाहिए, उसके बेसिक बुक्स आपको कंसल्ट करने चाहिए होते। एक है लॉ ऑफ कॉन्ट्रैक्ट, एक है सेल ऑफ गुड्स एक्ट, एक है ट्रांसफर ऑफ प्रॉपर्टी एक्ट और एक है स्पेसिफिक रिलीफ एक्ट। ये 4 बेसिक चीजें हैं। उसके अलावा अब अगर किसी कंपनी का मसला है तो कंपनीज एक्ट आपको मालूम होना चाहिए, मर्जर एक्विजिशन का मसला है तो उसके बारे में जानकारी होनी चाहिए। लेकिन जो फंडामेंटल बेसिक लॉज है, ये 4 लॉज जो बेयर एक्ट्स हैं, इसकी मास्टरी, इस सब्जेक्ट की मास्टरी जितने हद तक आप कर सकते हैं उतना करिए। अच्छे बुक्स पढ़िए ताकि आप उन सब्जेक्ट्स को समझ सकिए। तो जब आप ये करते हो तो उससे ये आपको पता होता है कि ये सब बेसिक लॉज, बेसिक लीगल प्रिंसिपल्स क्या है। तो जब आपके सामने कोई आके बात करना शुरू करता है अपने प्रॉब्लम का, कि जैसे ही लोग बोलते हैं कि हमारा ये डिस्प्यूट है, एक साइड ये कह रही है, मैं ये कह रहा हूं, तो आपने जो बेसिक लॉज के जो फर्स्ट प्रिंसिपल्स पढ़े हुए हैं अभी तक, वो आपके दिमाग में, जहन में आने लगते हैं। अरे ये तो, इसमें तो कॉन्ट्रैक्ट ही कंक्लूड नहीं हुआ, अरे ये तो कॉन्ट्रैक्ट कंक्लूड नहीं हुआ, तो लॉ ऑफ कॉन्ट्रैक्ट में मैंने लॉ स्कूल में फर्स्ट ईयर में पढ़ा था। तो आप, अच्छा, दूसरा, जब आपके पास क्लाइंट्स आता हो, जैसे क्लाइंट ने कहा कि हमारा ये डिस्प्यूट है, फोन पे बात हुई, कागज भेजा, तो उससे जो रिलेटेड लॉज है उसके बारे में बेयर एक्ट या थोड़ा बहुत केस लॉज में थोड़ा पढ़ के पहले से तैयार रहिए। तो जब क्लाइंट से आप डिस्कस करें, एक तो क्लाइंट से ज्यादा समझ पाएंगे और क्लाइंट को भी आप पर भरोसा होगा कि मेरा जो वकील है वो सब्जेक्ट को जानता भी है और मेरे लिए मेहनत भी करेगा। और दूसरा, एक ऑनेस्टी जरूर होनी चाहिए। क्लाइंट आपके पास बैठा है नहीं बैठा है उससे कोई फर्क नहीं पड़ता। ये बहुत इंपॉर्टेंट बात है किसी एडवोकेट के लिए, कि आपने किसी का केस लिया है तो क्लाइंट आपके पास हो ना हो, कितने पैसे दे रहे हैं नहीं दे रहे, आपको अपना 100% देना चाहिए। ये बड़ा ही इंपॉर्टेंट होता है, तभी आपका ग्रोथ होता है और तभी केस का भला होता है।
ये बात तो आपने ठीक कही कि यू हैव टू कीप योर बेस्ट फुट फॉरवर्ड, मे बी ड्राफ्टिंग, मे बी इट्स आर्ग्यूमेंट्स, मे बी इट इज प्रिपरेशन ऑफ द केस। फील्ड नहीं आ गई आपने तो, चलो एक यू हैव क्रिएटेड योर ओन नीच। उसको इमीडिएटली क्या क्या थॉट प्रोसेस अपने दिमाग में लाने चाहिए कि क्लाइंट को ये ना लगे कि ये तो फर्स्ट टाइम है। और
आपकी आवाज आनी पारी कट रही है।
के पास कोई क्लाइंट जाता है तो उसको उससे पहले क्या तैयारी रख लेनी चाहिए कि भाई वो क्लाइंट को लगे कि ही इज आल्सो नोइंग द सब्जेक्ट।
देखिए, मैंने यही कहा अभी कि क्लाइंट जब आपके पास फोन करता है या आना चाहता है, कोशिश करिए कि क्लाइंट आने से पहले आपसे कुछ फोन पे अगर बात कर रहा है तो कुछ इंफॉर्मेशन दे रहा है तो अच्छी बात है, नहीं दे रहा है तो उनको बोलिए कि भी जो भी आपके कागज हैं वो भिजवा दें, ताकि उनके आने से पहले आप उसको पढ़ लें और उसके बाद जो रिलेटेड लॉज हैं उसको जरूर गो थ्रू कर लें, ताकि जब आप बैठें तो आपको कुछ पता रहे और तभी क्लाइंट का कॉन्फिडेंस आता है। आप जजमेंट्स लेके तैयार रहिए कि देखिए इस पे ये जजमेंट है, इसके कारण से आपका केस अच्छा है, ये जजमेंट है जो दूसरी साइड के फेवर में है, अच्छा उसका भी फिर ये जवाब है, ये मैं तैयार होके बैठा हुआ, कॉन्ट्रैक्ट के ये प्रोविजन है, बेयर एक्ट्स अपने आजू बाजू रखिए, जहां भी ऑफिस में बैठिए फटाक से उनको सेक्शन दिखाइए। तो यही सब तरीका है, उसी से कॉन्फिडेंस आएगा क्लाइंट।
बहुत बहुत शुक्रिया। और ग्रुप में राइट साइड की चैट में यही आ रहा है कि बहुत उम्दा सेशन रहा। एंड नीडलेस टू ऐड, इवन इफ इट वुड नॉट हैव बीन रिटन, आई एम क्वाइट श्योर दैट लॉट ऑफ पीपल हैव learned the nuances, and they say that even if you have the best of the acts, you with time, and that is the key mantra for the profession also, that you have to by reading, by revising your notes, by doing the proper networking with right at right place, and I'm quite sure that people will learn from this. आशा करते हैं सब स्वस्थ रहेंगे और हमारे साथ जुड़े रहेंगे, आगे और सेशंस आते रहेंगे। रतन जी के साथ रह के कई और ऐसे अमूल्य रतन उनसे लेते रहेंगे और रतन जी के साथ साथ बाकी लोग भी हमें नॉलेज देते रहेंगे। सो हमारे साथ कांटेक्ट रखें व्हाट्सएप पे, और चैनल जिन्होंने नहीं देखा, पहले जस्ट सिंह ने पहले भी एक सेशन दिया हुआ है, उसे भी देखें। एवरीवन स्टे सेफ, स्टे ब्लेस्ड। थैंक यू, नमस्कार।